everyone. This is Laura from The Real Laura B here on YouTube and Twitter. Today, I'm going to bring you another video on the pre-trial battlefield, this time with Disney. Amber Heard subpoenaed Disney, then tried to compel them to provide more. It was taken to the LA courts, then tried to sanction them. So this, again, so much going on behind the scenes before it ever gets to the trial. And I don't think Amber Heard got what she wanted. But that's what I'm talking about today. So let's get started.
Hi, I'm Laura, also known as The Real Laura B from Twitter, and now here on YouTube. I'm a researcher, new wave internet media, and commentator. I'm not a lawyer, nor offering any legal advice. Join me on a journey to review the world of celebrity lawsuits and current events. Let's get started.
So just a reminder, when someone's issued a subpoena out of Fairfax, the governing body over that subpoena is where the resident of that business is or person, and Disney is, legal residence of their business is in California. So anytime they had an argument about the subpoena, whether to quash it, to limit it, to meet and discuss about it, it was handled in the courts in LA, and Fairfax would abide by that. So that's where we're starting with today. There was a subpoena. I don't need to get into subpoena. I think it might be included in some of the documents, but that's not important. Basically, they want to know everything about, did they know about the op-ed? The op-ed affect them hiring Johnny? Were they going to hire him? Were they not? Etc. So this is, I'm going in date order from the documents that were available to me. We'll start off here with Amber Heard's lawyer at the time was David Brooke. This is June 2020. And they're trying to negotiate what is needed in the subpoena. And let's see if I can make it bigger for you. There we go. I think that's pretty big. So this is June 12th. So this is what's in court documents. Davida, this is Disney answering, not Johnny's lawyers. This is Disney's lawyers. Davida, Amber Heard's attorney, following up on our conversation yesterday, we can produce documents responsive to the following categories unless otherwise stated. The date limitation of these categories will be January 1, 2010 to present, consistent with the original subpoena. Communications by or to individuals with input into casting of the 6th Pirates of the Caribbean movie referencing Amber Heard and Johnny Depp. Communications by or to individuals with input into casting of the 6th Pirates of the Caribbean movie referring or relating to the op-ed first published in the Washington Post on December 18, 2018, online titled Amber Heard, I spoke up against sexual violence and faced our culture's wrath. This has to change. Or issues discussed herein during the period of time after it was published and before Disney first made publicly known in December 10, 2018 news article that it would not be recasting Mr. Depp for a future Pirates of the Caribbean movie. Contracts with or relating to Mr. Depp and the Pirates of the Caribbean franchise dated January 1, 2015 to present. Non-privileged documents or communications concerning any insurance policy or claims relating to any performance by Mr. Depp from January 1, 2015 to present. If this is not consistent with your understanding of our conversation, please let me know and we can have another conversation. Otherwise, we should be in a position to produce responsive documents shortly. We do not require another subpoena if we are in agreement on this refinement of the original subpoena. So they've had meet and confers. We have proof and acknowledgement here that they've narrowed down the subpoena. It's not specifically what it was originally requested. They've come to a meeting of the minds. We agree that any deadline to move to compel will run from 2 business days after we produce responsive documents. Finally, we may need to withhold some documents until we receive a HIPAA waiver from you. And we know that Johnny did sign one. So jump ahead now. This is filed June 30th, 2020, and I'll make that bigger. So this was June 12th, 2020, and only 2 weeks later. And let's make this bigger for you guys. We have new lawyers. Davida Brooks is out. And it's been replaced by these California attorneys. Now, remember, Davida Brooks would have been coming in when Robbie Kaplan came in. So they're out now. This is June of 2020. New lawyers. New arguments, apparently. Introduction. Petitioner Amber Laura Heard, the defendant in an out-of-state action filed in Fairfax County, Virginia, submits this memorandum of law and facts in support of her motion to compel subpoena a compliance served upon third-party Walt Disney Motion Pictures Incorporated, Disney. Heard previously filed a petition in this court, petition and memorandum to enforce subpoena pursuant to the Code of Civil Procedure, filed October 29, 2019. The parties have met and conferred in an attempt to resolve this matter without seeking the court's intervention. When we saw that email, we assume they did. Petitioner Heard is a defendant in the action filed in Fairfax County. Depp v. Heard, we know about that. This is the history, the relevant background. On February 6th, counsel for Heard properly served Disney with a subpoena, February 2020, to produce documents as provided by the Interstate International Depositions and Discovery Act. We know about that. Declaration of Cogger to support the petition is attached. At the time, Ms. Heard was represented by Sussman Godfrey. On or about February 14th, Disney produced objections to the subpoena to the deposition officer. These objections were provided to counsel by Heard, March 23rd, 2020. For several months, the parties communicated in an effort to negotiate the proper scope and subject of the subpoena. In the course of those three communications, the parties repeatedly extended the deadlines for Disney to produce documents and for Ms. Heard to file any motion to compel further production. Following extensive correspondence between counsel for Ms. Heard and counsel for Disney, the two agreed upon a narrowed list of production categories. The agreement was memorialized in an email from Disney to Ms. Heard's counsel on June 12th. The email defined 4 categories of documents for production and clarified the parties' agreement that following Disney's production of documents, Ms. Heard would have a shortened period of time, 2 business days, to file a motion to compel further production. There was no agreement as to the date on which Disney would produce the documents. Following the substitution of counsel on or about June 22nd, Ms. Heard's new counsel at Gordon Reese Scully Manzucani attempted to meet and confer with Disney as to the outstanding subpoena. On Thursday, June 25th, counsel for Heard sent an email to Disney introducing themselves as Heard's new counsel and attempted to meet and confer regarding the documents that had still not been produced in response to the February 6th subpoena and June 12th agreement. 2020. On Friday, June 26, 2020, at approximately 5:30 p.m., Disney sent its response to the subpoena and provided access to the documents it produced to former counsel. With the documents, Disney served 3 declarations by custodians of records. None of the declarations indicated that Disney was not in possession of records responsive to documents within certain categories, or that Disney was only in possession of some of the documents. Nonetheless, Disney failed to produce documents responsive to 2 of the 4 request categories. In addition, Disney's failure to produce responsive documents and failure to provide an affidavit declaring that they are not in possession of such documents. Disney failed to provide a privilege log and failed to state that they have produced every responsive document in their possession. Every responsive document. On Monday, June 29, 2020, counsel for Heard sent an email to Disney to meet and confer regarding the insufficiency of Disney's document production and or declarations of the custodians of record. Following communications between the parties on Monday, June 29, 2020, Disney produced 2 affidavits. The first certified that Disney produced documents responsive to the subpoena request for communications by or to individuals with input into casting of the 6 Pirates of the Caribbean movie, referencing Amber Laura Heard and Johnny Depp. The second newly produced affidavit certified Disney was not in possession of the subpoena category seeking communications by or to individuals with input into casting of the 6 Pirates of the Caribbean movie, referring to or relating to the op-ed first published in the Washington Post on December 18, 2018, titled Amber Laura Heard, I spoke up against sexual violence and face our culture's wrath. This has to change. Or issues discussed therein. During the period of time after it was published and before Disney first made publicly known in a December 20th, 2018 news article that it would not be recasting Mr. Depp for a future Pirates of the Caribbean movie, Disney did not state any efforts it made to locate responsive documents or that they had produced every responsive document. Additionally, Disney provided no privilege log for any documents it may have produced and for which it may claim privilege. Counsel for Ms. Heard attempted to further meet and confer and requested until July 3rd, 2020, 3 additional days during which the meet and confer process could continue and motion practice could be avoided. Disney refused, necessitating the instant petition. This is going to get good, guys. The petition of enforcement for subpoena that relates to out-of-state proceedings is governed by the International Depositions Discovery Act. We know that. In order to obtain the deposition of a non-party or party-affiliated witness, the party seeking deposition must serve a subpoena to compel the witness attendance, testimony, or production of documents. They want both documents and somebody they call the person most knowledgeable, PMK, to give a deposition on this subject. When a subpoena ducis tecum, I'm sure I'm saying that's wrong, but that's the document one, is served upon the custodian records or other qualified witness of a business in an action in which the business is neither a party nor the place where any cause of action is alleged to have risen, and the subpoena requires production of all or any part of the records of the business, it is sufficient compliance therein if the custodian or other qualified witness delivers by mail or otherwise a true, legible, and durable copy of all records described in the subpoena to the clerk of the court or another person described, etc. My goodness. So this is all the code. The record shall be accompanied by an affidavit. The affidavit is duly authorized. The copy is true and copy of the records, etc. The records must be accompanied by the affidavit of the custodian of records or other qualified witness, along with an affidavit stating each of the following. The affiant is the authorized custodian. It's a true and correct copy. A deposition subpoena is enforceable by motion to compel compliance. These rules are applicable to subpoenas issued by courts in other states. We know that. That's what we were just talking about. It was issued in Fairfax. It's now going to be enforced and discussed here and ruled on in California, the resident of Disney. In response to a properly served deposition subpoena for the production of business records, the custodian of the records or other qualified personnel should in person, by messenger, by mail, deliver it all, true and exact copies, etc. So let's get to the meat of it. Disney failed to produce records and failed to deliver required affidavits. Disney produced records on June 26, 2020, accompanied by declarations of custodians of record for insurance and claim records, contract records, and general gathering of documents responsive to the subpoena. None of the records responded to two of the categories listed in the subpoena. Disney's declaration failed to state that Disney had no documents responsive to those categories or only some of those records described. Additionally, Disney did not produce a privilege lodge for any documents it may not have produced. Following Heard's further attempts to meet and confer with Disney, on Monday, June 29, 2020, Disney produced an additional affidavit certifying it produced documents responsive to one subpoena category, and second new affidavit certifying Disney was not in possession of the remaining subpoena category. Disney did not state any efforts it made to locate responsive documents. Disney did not state that they produced every responsive document to the subpoena. Additionally, Disney did not produce a privilege log for any documents it may not have produced for which they claim privilege. Here, Disney failed to identify with particularity what categories the materials provided responded to. Though Disney served multiple declarations of custodians of record, including that of custodian for insurance and claim records, custodian for business records, and that of the attorney responsible for the production of documents on behalf of Disney, Disney nonetheless failed to specify that a copy of the materials produced were all the records responsive to the subpoena as required. Disney failed to specify the identity of the records as required. Disney failed to specify that it had none of the records requested or only part therein as required. Disney failed to include a declaration of counsel that the copy is a true copy of all the records delivered to the attorney or his or her representative or deposition officer for copying as required. Disney failed to provide any privilege log as part of the production as required. Disney's failure to comport with Evidence Code Sections 1560 and 1561 are tantamount to no production at all. With a shortened time to file a motion to compel simple compliance with the subpoena, this issue should have been easily worked through. Heard's counsel sought 3 days to attempt to work through these deficiencies, but Disney's counsel refused. Disney's production, as it is not in compliance with the law, leaves it to chance whether the documents produced are all the records described in the subpoena, as required. The law requires clarity in that regard. Based on the foregoing, Disney's production of business records fails to comply with production requirements set forth in the Code of Civil Procedure and Evidence Code. Ms. Heard respectfully requests that the court compel Disney to produce further responsive documents and serve an affidavit in compliance with Evidence Code 1561. Here we go. Sanctions are warranted for Disney's abuse of the discovery process. If a deponent fails to produce any document under the deponent's control that is specified in a deposition subpoena, the party seeking discovery may move the court for an order compelling that answer or production. If the court determines that the production sought is subject to discovery, it shall order that production be made in accordance with the Discovery Act. The court is authorized to award as sanctions the moving party's reasonable expenses, including attorney's fees, for the motion to compel. Reasonable expenses include the time moving party's counsel spent in research and preparation of the motion and court time in connection with the motion. Here, in failing to appropriately respond to Ms. Heard's subpoena, Disney has deprived Heard of information relevant to defend claims and damages alleged against her in the underlying action. Further, Disney has called Ms. Heard to incur the unnecessary time and expense of preparing the instant motion. Bringing this motion, including basic legal research, drafting all moving papers, hearing appearance, and associated costs, will cost Ms. Heard approximately $3,877.50. These expenses would not have been incurred had Disney simply cooperated and fulfilled its legal obligation in the discovery process. Accordingly, Ms. Heard requests that the court require Disney to pay those sanctions. In conclusion, for the foregoing reasons, Ms. Heard respectfully requests that this court grant this motion and order Disney to provide documents requested by subpoena or subsequent agreement and to properly serve an affidavit in compliance with the Evidence Code Section 1561. Ms. Heard further requests the court do not order Disney to pay sanctions to Heard in the amount of $4,773.50. I'm not sure what increased it from $3,877.50. So she's threatening Disney. Now we have a status report. Don't be panicked where it says Mandel Company. The first subpoena they argued was the Mandel Company. So that's the starting of these subpoenas. They all came together in one case. This is now into the Disney part of it. So ignore that part because they just kept adding subpoenas to the original motion to compel. And that's why their name is still there. Joint status report of petitioner Amber Heard and third party Walt Disney. I don't have all the documents on this. Some of them, I guess, were sealed and not uploaded, but I have enough for the continuity of the story. So this is the status report that happened September 16, 2020. Let me watch your eyes. It looks like there was no hearing set when they were filing to compel. A petition to compel further responses to deposition, subpoena, and for sanctions was filed on behalf of Ms. Heard against Disney regarding document production, responses, and declarations provided by Disney responding to a subpoena request by Ms. Heard that failed to include this paragraph is like an entire sentence. That failed to include necessary declarations in conformity with the Evidence Code Section 1561. The hearing on the petition for relief is scheduled for February 2021. Okay, so there's a hearing ways away yet. There are 4 categories of documents in the subpoena. They want all of the records. Those declarations do not indicate substance or any fashion that all of the records have been provided. So I'm just jumping around. We don't have to read every paragraph and word. Evidence Code 1561 requires that when documents are produced pursuant to a subpoena, that the records be provided with the declarations provides as follow. A copy is true copy of all the records described in the subpoena, or pursuant to subdivision, the records were delivered to the attorney's representative or the place of business. Ms. Heard simply wants Disney to comply with the requirements that Disney affirm under penalty of perjury that the materials provided are a copy of all the records described in the subpoena. Disney refused to do so, necessitating the petition scheduled to be heard February 2021. Disney continues to refuse to sign declarations that the materials provided are all of the records described in the subpoena. Copies of declarations that Ms. Heard seeks to have Disney sign under penalty of perjury are attached in Exhibit B to this joint statement. Upon Disney's representative signing the declarations, Ms. Heard will withdraw her petition. And what does Disney have to say about this? Disney cannot declare that it has produced all documents in its possession because that is not what counsel agreed to after extensive negotiations on the scope of the subpoena at issue. That's why I read that email first. They were negotiating with Davita Brooks. New counsel came. They had an agreement. Then new counsel came in. As counsel for Ms. Heard stated above, Disney has already produced documents along with accompanying declarations in response to the subpoena. Those declarations contain the same wording Disney's counsel had used in hundreds of declarations for over a decade, all without a single complaint from a subpoenaed party until now. The language of these declarations fulfills the requirements of Evidence Code because it states in substance that is required, the record shall be accompanied by the affidavit of the custodian or other qualified witness stating in substance each of the following. Emphasis added. Counsel for Ms. Heard omitted this language from the citation of the code. Oh, we're so surprised, right? More importantly, Ms. Heard's previous counsel stated to Disney's counsel that they did not want or expect all the documents in Disney's possession. During negotiations over the scope of the subpoena, it became clear that this is important, guys. It became clear that their strategy was to show that Disney did not have documents showing a link between Ms. Heard's public statements and Mr. Depp's career, so as to minimize her damages. For that reason, they suggested that Disney perform a limited search. Disney has no vested interest in the outcome of this case, but it does have an interest in minimizing the resources it expends in responding to the third-party subpoenas. After multiple telephone and email conversations between counsel over the course of several months, Disney's legal staff interviewed key document custodians and reported back to Ms. Heard's counsel what documents were readily available. Ms. Heard's counsel stated that those documents would be sufficient. This is important. Johnny was claiming he lost his role in Disney because of her op-ed, because a few days after the op-ed was written, an executive for Disney announced that they're going to give Pirates of the Caribbean 6 a kick in the butt, and we're going to recast Johnny. So DeVita Brooks negotiates the subpoena with Disney to make sure, and that's what's important here, over the scope of the subpoena, it became clear that their strategy was to show that Disney did not have documents showing a link between Ms. Heard's public statements and Mr. Depp's career, so as to minimize her damages. So they were negotiating to make sure, look, we don't want anything that has mentions about the op-ed and stuff. We only want things that don't mention the op-ed, for example. So Disney has no vested interest in this. They decided to go with the minimum amount that DeVita Brooks negotiated they needed. Here we go. Around the time Disney produced those documents, it was told that Ms. Heard had hired new counsel. Her new lawyers then insisted that Disney modify the declarations accompanying the production to state that it produced all documents in its possession. But Disney's employees cannot sign statements under penalty of perjury that they provided every copy of every possible document in Disney's possession, given the limited search Ms. Heard agreed to through her previous counsel. Non-party Disney is now being hailed into court, faced with the classic bait and switch, in which one counsel agrees to accept a certain set of documents, and then at the last minute, new counsel says that's not good enough. Disney has more than complied with its legal requirements and should not be burdened further with subpoenaing counsel's trivial preferences. When dealing with an entity which is not even a party to the litigation, the court should attempt to structure discovery in a manner which is least burdensome to such an entity. So they were complying. They were doing everything they were asked to do via DeVita Brooks. And we saw that email from her. So this is, I want to make sure this is the draft. Yeah, see, this is the draft that they want him to sign. And they're saying, no, we're not going to sign this. We're not going to say that we have provided every single document that could possibly exist. These are the draft. These are why they're not signed. These are drafts that they want Disney to sign. And they said they're not going to sign it. Nope. So now we jump to January 2021. This is before the hearing is going to happen. Non-party Disney Motion Pictures is opposition to the petition to compel further responses. So now they've had a lot of meet and confers. They had their where they have their conference, their status update to the court. And they're still arguing back and forth. And they're like, look, this is what's going to happen now. This entire dispute is over a single word absent from the declarations that accompanied non-party Walt Disney Motion Pictures Group, Disney, complete production in response to Heard's document subpoena. After extensive telephone and email discussions and negotiations, Disney and petitioner's former counsel agreed on the documents that would satisfy the requirements of the subpoena. Disney then performed a thorough search of electronic and paper records and produced those responsive documents, along with accompanying declarations by the document custodians. Petitioner then hired new counsel, who is now insisting that those declarations state that Disney produced all documents in its possession. But Disney's document custodians cannot so declare because that is not what the parties agreed to, nor what the law requires. This frivolous petition should be denied, as should be the absurd request for sanctions against a non-party that has made a full document production. After meeting and conferring with the petition's former counsel numerous times over the course of several months, that's the previous counsel, After receiving the subpoena, Disney's legal staff interviewed key document custodians about what documents they had were relevant to the case. Disney's counsel then reported back to petitioner's counsel what documents it had found, and petitioner's counsel stated that those documents would be sufficient. Because remember, they really don't want any documents that mention the op-ed or Johnny's firing or anything else that could put the two together. Disney produced those documents and the accompanying custodial declarations. Petitioner's new counsel, who did not participate in the conferences between counsel, now appears to argue that Disney's custodians declare something that is not true and could never be true. That those custodians know for certain that every document in Disney's possession has been reviewed. That is not what the law requires of non-parties responding to subpoenas. And it certainly is not what the parties agreed to in this matter. Petitioner cites no case law for the proposition that declarations accompanying a custodial declaration must contain the word all, because no court has ever so ruled. Instead, petitioner has cherry-picked language from the California Evidence Code as the only legal authority, but the code does not require precise language for declarations. Rather, it says that records shall be accompanied by an affidavit of the custodian or other qualified witness stating in substance each of the following. That is precisely what Disney provided with its full and complete production. The language of these declarations state in substance that the agreed documents have been provided by the custodian, that they are true copies, and that they were kept in the ordinary course of business. Petitioner's insistence on including the word all would not only be inaccurate, it would make no difference in whether the produced documents could be introduced at trial. Further, even if it were true that the evidence code requires the word all to be a custodial declaration, petitioner waived any such requirement by agreeing that specific documents would satisfy the subpoena. As for petitioners, that's Hurd's, preposterous request for sanctions, it would be entirely inappropriate for a non-party to be punished for complying with its legal obligations and the agreement between the parties. When dealing with an entity which is not a party to litigation, the court should attempt to structure discovery in a manner that is least burdensome to such an entity. Although the parties continue to confer to resolve this dispute, should this petition be heard, the court should reject petitioner's odd insistence on language that is of no legal consequence and is a result of a bait and switch that has prejudiced Disney, not the petitioner. Proof of service. And I want to make sure that Johnny's attorneys from California that are all getting copies of this. So they're all in the loop. So here we have on the ruling. Got it all? Nature of the proceedings, ruling on submitted matter, reheard, basically versus Disney, and for sanctions. After consideration of the briefing filed and oral argument on the hearing, Amber Heard's petition to compel further responses to deposition subpoena to non-party Walt Disney Motion Picture Group and for sanctions is denied in part and granted in part. The motion is denied as the request of further responses. Boom. So Davida Brooks got her way. We want these specific documents, and Disney is saying that they did like a modification to make sure that they didn't get anything mentioning the op-ed. And Disney was like, look, we're not involved in this. We have no horse in this race. We're just going to give them what they want. So that part was denied. The motion is granted to the extent that non-party Walt Disney Motion Pictures Group has withheld production of any documents under the claim of privilege as to any category of documents, and corresponding privilege log has not been produced. A production log is ordered to be produced within 20 days if applicable. Since it is unclear from the opposition if any documents have been withheld under the claim of privilege, Disney's request for monetary sanctions is denied. So Disney got frustrated and apparently has also asked for sanctions. So here's the discussion. Petitioner Amber Heard's objection to the declaration of Alexander Myers in support of non-party Walt Disney Motion Pictures opposition filed on February 8, 2021 is sustained. The court finds that the declaration is not signed as required under Code of Civil Procedure section, including that it was signed under penalty of perjury under the laws of state. So they apparently filed some declarations that were not signed. The court, however, does consider the oral representations of Mr. Myers at the hearing for this motion regarding his extensive meet and confer efforts and negotiation with petitioner's former counsel and current counsel before and after the informal discovery conference was conducted with this court. The court finds that petitioner does not dispute that the subpoena was issued by Ms. Heard prior counsel, and previous meet and confer efforts were made between counsel for non-party Walt Disney Production Company Group Incorporated and petitioner's prior counsel before petitioners, this is so many petitioners, current counsel took over the case. The court also finds that there is no declaration submitted by Amber Heard from her prior counsel about what was agreed to in the meet and confer. So they were bearing that. That contradicts Mr. Meyer's oral statements and arguments to the court that everything that was agreed to between the parties has been produced by Disney. The court also considers discussions that took place at the informal discovery conference. So there's a lot of verbal back and forth. The judge is aware of that. We are not. The court considers the declaration of John P. Cogger and the attached exhibits in support of this motion. Exhibit D provides 3 declarations stating that non-party Walt Disney Motion Pictures Group was producing responsive records, contract records, insurance records, business records. Exhibit F provides 2 supplemental declarations stating that there were no responsive records regarding communications falling under the 2 categories of the subpoena in the email from Cogger. Upon review, the court finds that the supplemental declarations directly address the deficiencies outlined in Cogger's email as of June 29, 2020. Petitioner fails, that's Heard, to submit any further written meet and confer communications from Heard's counsel, the previous counsel, to non-party Walt Disney, occurring after June 29, 2020. So even post that, they didn't provide any communication. That outlines any additional deficiency or problems after the supplemental declarations dated June 29, 2020 were received. Further, there are no statements from Cogger, that's her new attorney, in the supporting declaration to this motion regarding such. The instant motion was filed the next day on June 30th, 2020. Therefore, the court finds the petitioner has failed to sufficiently meet and confer in good faith with Disney regarding any additional deficiencies raised before the instant motion after the supplemental declarations were received. The court does not find that it would be fair or just to require non-party Walt Disney Motion Pictures to now start all over again with a new search of responsive documents and draft new responses to the subpoena as it's requested here by Heard, merely because current counsel was not part of previous meet and confer discussions with prior counsel for Ms. Heard. It would also be unduly prejudicial as argued by Disney. Accordingly, the court finds that non-party Disney has sufficiently produced responsive documents and declarations on behalf of the non-party Walt Disney Motion Picture Group in response to the deposition subpoena at issue. The motion is denied as to the request for further responses. The motion is granted to the extent that Disney has withheld production of documents under the claim of privilege as to any category, and a corresponding privilege log has not been produced. A production log is ordered to be produced within 20 days, if applicable. So they don't even know if they've held back things from privilege, but they probably have. Joint status report. I've already read this. I want to go back to this paragraph. More importantly, during negotiations over the scope of the subpoena, it became clear that Amber Heard's strategy was to show that Disney did not, emphasis underlined, did not have documents showing a link between Heard's public statements and Depp's career so as to minimize her damages. For that reason, they suggested that Disney perform a limited search. Disney has no vested interest in the outcome of this case, but it does have an interest in minimizing the resources it expends in responding to a third-party subpoenas. So I don't know if they have it or not, but they weren't helping Johnny out with it, that's for sure. Now, these apparently were unsigned declarations of Myers. I'm the custodian of the records. The copies attached or records hereto are true copies of all business records in possession of Disney as described in the subpoena. Communications by or to individuals with input into casting of the parts of the... So are they going to... So referencing Amber... So they very, very limited. Casting of Pirates of the Caribbean, referencing Amber Heard and Johnny Depp. The records were prepared and received. I have conducted a good faith diligent search of the records, other than records produced herewith or otherwise. I declare under penalty of perjury under the laws of California that you can correct to the best of my knowledge. So here's what they wanted. Communications, this is what they negotiated down to. Communications by or to individuals with input into casting of the 6th Pirates of the Caribbean, referencing Amber Heard and Johnny Depp. Interesting wording. And they only talk about Myers. After conducting a good faith, diligent search of records in the custody of possession of Disney, no records were found responsive to the category communications by or to individuals with input into casting of the sixth Pirates of the Caribbean movie, referring or relating to the op-ed first published in the Washington Post on December 18th, titled, this has to stop. This has to change, or issues discussed therein during the period of time after it was published and before Disney first made publicly known in December 20th, a news article that it would be recasting Mr. Depp for the future Pirates of the Caribbean movie. So they're unable to provide those requested documents on that category. And this is that Tina Newman now comes in. She's not even mentioned. So she's supposed to provide contracts or relating to Mr. Depp as far as she knows. She has done a good faith effort to search, and they provided them. Matthew Ruffner, he's a custodian, and he was supposed to records of insurance and claim records in possession. Now, I don't remember any of that coming up in trial, insurance and claim records. Records are prepared other than records produced herein, otherwise accompanied by privilege log herewith. So this is where you might get into the privilege. Now, remember that Warner Brothers provided their top executive to give a deposition. Disney was supposed to provide their person most knowledgeable with Johnny's claims that he was fired after the op-ed. They provided a production executive from a Disney motion picture group. A production executive, someone who deals with production. So some of the questions she asked, did you know anything about an op-ed? Did they show you an op-ed? She's in production. Why would she get any of that information? These are the higher ups, the top echelon CEOs that would be discussing this multi-billion-dollar project and their top actor, whether they're going to use him again or not. It's not going to be at the lowest production executive. That's her title from Disney. So there is questioning back and forth. I'll link this at the bottom, but this is probably the most important part. Sorry, guys. I know, I forget. I have to share this a different way. So let's share this.
Know whether Mr. Depp is being considered for a role in Pirates 6?
No.
And when you say no, I think I have to probably ask clarification. Does that mean you don't know one way or the other, or he is not being considered?
I don't know one way or the other.
Do you
Doesn't
know?
fall.
I'm sorry, go ahead.
I was just going to say that decision doesn't fall within my job responsibility. It's above my head.
So they didn't send the person most knowledgeable. And I can link the rest of this and we can listen to it. But the point is, she knows nothing about Johnny's role,
That's the way to say it.
potential role in Pirates of the Caribbean, etc. Sorry, I don't know why that happened. So I'll link that below. But that's pretty much what happened. The jury found unanimously for Johnny Depp and damages of $10 million plus $5 million punitive that was reduced. So they found that she defamed him, and they found there was at least $10 million in damages. So found that interesting, and yeah, not the person most knowledgeable. So this was a quickie. I can't link the documents below. I had to buy them. My links that I use are not accessible to you without my account information, but I did buy all of these, and I hope that gives you an idea of what was going on behind the scenes, the pre-trial battlefield that is to get Disney to produce documents, to produce a person most knowledgeable to be deposed, who obviously was not the person most knowledgeable. I'll link that to the bottom too. But anyway, this was a quick one. Thank you for joining me, and link, subscribe, share. I appreciate all the help. And that's it for today. Thanks, guys. Have a great one.